Teamsters Union held a protest in Halifax this week against the federal government's decision to impose binding arbitration in a dispute with Canada's two major railway companies. Canadian National and Canadian Pacific Kansas City locked out roughly 10,000 workers from Teamsters Canada Rail Conference last week after contract negotiations reached an impasse.
We've been locked out by the company. We're willing to go to work, and we're willing to negotiate at the bargaining table.
The union was prepared to strike over issues including what they called the gutting of employee fatigue provisions, but a coordinated lockout by CN and CPKC preempted the strike action. Under pressure from business, the federal labor minister directed the Canada Industrial Relations Board to order the companies to resume operations and the employees back to work. He also told the CIRB to impose binding arbitration and to extend the collective agreements until the arbitrator had imposed a new deal.
As Minister of Labour, I am using my authorities under the Canada Labour Code to secure industrial peace and deliver the short and long-term solutions that are in the national interest.
The Teamsters said they would comply, but vowed to fight the decision in federal court, saying it violates their constitutional right to strike. For more on the story, the NB Media Co-op spoke to Stephanie Ross, a professor in the School of Labour Studies at McMaster University in Hamilton, Ontario. This interview was recorded on August 22nd, a few hours before Labour Minister Steve McKinnon announced binding arbitration. Well, first, maybe we should talk about the difference briefly between a strike and a lockout. I believe the union has put forward a strike notice. They were in a legal position to strike after members overwhelmingly voted to strike, I believe, twice this year. Meanwhile, the companies issued lockout notices. Briefly, what's the difference and why is this important?
Yeah, I mean, in our labor relations system, strikes and lockouts are sort of created as equivalents, I suppose. That in bargaining, each side has to be able to have some tool to pressure the other to change their bargaining position. And so, a strike is when a group of workers withdraw their labor in order to increase their leverage in a bargaining situation to try to convince the employer that it's actually more costly not to agree than to agree. And then conversely, the employer legally has the right to basically lock out its employees in order to try to get the settlement it wants. And so that means shutting down the facility, or sometimes trying to run the facility with non-union workers in order to put pressure on the union and its members to agree to a settlement that they wouldn't otherwise prefer. And so, this is these strategies, these tactics, I guess, are embedded in and legally protected in our labor relations system and the legislation that that supports collective bargaining, I should say. But there is some important difference to these strategies. I mean, when workers go out on strike, they are really exercising one of the very few forms of power that they have in the employment relationship. They really don't have control over their working lives or over the company more generally, except insofar as they can put this kind of pressure on the employer. The employer generally, and this is especially true in this case where we have two private sector for-profit employers, they the people who make the decisions in those companies, they have a lot of control over the workplace, how it's designed. They may also have investments in other industries. And so, the impact on them when they lock workers out is not so immediate and direct on themselves. I'm quite sure that all of the CEO and all of the executive cadre of these corporations are still going to be taking their money home at the end of the day. Whereas in a strike, people who are on strike, but also people who are locked out, are not being paid. They're not being paid by the employer. They are foregoing their wages in order to exercise this form of collective power. And so when workers do that, when workers take the step to go out on strike, they are taking a lot of risk. But they're making the calculation that the risk to their immediate wages and in the short term is worth it their in terms of what they could win in terms of wages and other improved working conditions in the long run. So, in that sense, this is a situation where the risk is very different to the parties. So it's true in a larger sense. These companies could, a company that locks out its workers could potentially experience economic decline, right? I mean, they're not going to be able to function as a business and take in revenue while the lockout is ongoing. But in this particular circumstance, these are two companies that basically dominate the rail industry in Canada. They are not going to lose business to competitors. Basically, they function as what we might call a duopoly in Canada. And so if we want products to move from ports across the country to the various parts of the country that are going to consume, whether through manufacturing or direct consumption by the consumer, we need these rail companies as things are currently organized. So they have a lot of power, not just with respect to these employees, but also with respect to their place in the Canadian economy, and they are certainly exercising it in this dispute.
Now, the union has said that both employers want concessions. Quoting from Teamsters here, CPKC aims to gut the collective agreement of all safety critical fatigue provisions. The end result will mean train crews would be forced to stay awake even longer, increasing the risk of derailments and other accidents. Of course, this raises the specter of the deadly events of 2013, Lac-Mégantic, Quebec, the rail disaster there. Not to mention last year's derailment in East Palestine, Ohio. CPKC says that nothing they've put forward creates any risk to public safety, and to say otherwise is patently false. So how can we make sense of this kind of claim and counterclaim?
Yeah, it's hard to do so when we're not at the bargaining table and we don't see what the actual proposals are. None of us have the bargaining language in front of us to be able to assess which side is correct. But one thing I will say is that, the Transportation Safety Board, the sort of federal agency that governs safety in the transportation sector in Canada, so that includes rail, airlines, shipping, marine travel, have consistently flagged through their assessments and reports that fatigue in these industries, worker fatigue, is an ongoing chronic issue that they are very concerned about. And while it's true that the federal government sets minimum standards for rest periods and so forth, it is the case that that the rail industry has been flagged for having chronic issues around worker fatigue. And so, without being able to say whether the company or the union in this specific instance is correct about what's at play at the bargaining table, there's no question that the federal government's agency has flagged this as an ongoing issue where improvements are needed. And so, in an important sense, CN Rail and CPKC really should be working to try to improve the conditions that reduce worker fatigue. What we also know in terms of context, though, is that many employers, including these ones, are talking about the difficulties that they are having in securing workers to do the work in their companies. Lots of employers have been talking about labor shortages since the pandemic and after, in the sort of the, we can call it the post-pandemic era. And one of the solutions that many companies have tried to have recourse to is to try to intensify the work that existing employees are doing, to try to get them to work more, to do more in their hours of work in order to be able to compensate for their inability to attract and retain new employees. People who are critical of this view say that really there's not a labor shortage as such. There's a shortage of workers who are willing to work for the wages and under the conditions that are being offered by many employers. Now, this is a sector where compensation is very good for people who are working in rail. There's no question that these are well-paid, well-compensated jobs, but we also have to understand them as very stressful and also highly skilled jobs. So it's not as though it's easy to just bring people in, train them up, and be secure and confident that they can operate rail traffic in a safe and responsible manner. That takes years, and it takes many years of planning, especially if you have a workforce that's aging out, that's retiring, that needs to be replaced. Like, that's not something that can just be fixed with a snap of the finger. And so, it is the case, though, that overall, we're in a situation where many employers are trying to find ways to fill the gaps that they perceive they have in their workforce by trying to get the existing workers to work more. And I think that that's what the union, in this case, what Teamsters Canada is trying to emphasize. So again, I can't really say who's right in this specific instance because I don't know what the language is on the table. But I can say that this is a trend across the economy, that many employers are wanting to intensify work for their existing workforce. And they don't necessarily want to increase compensation because that's exactly how they're going to increase profits and productivity.
And similar question here. The Teamsters say that CN has put forward what it calls a forced relocation scheme that would see workers ordered to move across the country for months at a time to fill labor shortages. CN, on the other hand, denies this, saying it would be on a voluntary basis and the workers would be compensated appropriately, and that this is already in place, a scheme of this kind, as part of regional agreements. So, kind of a similar question. It's very hard to know what's going on without being able to, lift the veil of these bargaining procedures. But, again,
Absolutely.
what do you make of the kind of claims and counterclaims in this situation?
Yeah, I mean, I think, this is what I would expect the parties to say about each other's position. I think that, there is a fear on the part of the union that what's now voluntary could become mandatory. And especially if there continues to be the kind of labor shortage pressure that they fear, that rather than trying to find ways to increase the available pool of skilled workers, we're going to move workers around where they are needed. So again, I can't comment on the specifics of these proposals because no one has them. But I think this does reflect, a larger trend, but also, what seems to me to be the case is that, something is there's a lot of conflict at the table, right? This impasse shows that that the parties are not working well to come to some resolution that both sides can live with. There is an impasse, and some of these are indicators that a third party really could be useful in trying to help the parties figure out where the zone of agreement, where the overlap between what workers need and what the company wants might exist. And so I think that when you have an impasse like this, and when you have, two companies that are willing to basically shut down the Canadian economy in order to get their way, that it's going to be very difficult for the federal government not to intervene in some way to try to get the parties talking productively back to the table and negotiating a solution pretty quickly. As our relations system has evolved over the last 10 years, it's much more difficult for the federal government and any governments to simply come in with back to work legislation, impose a process and an arbitrator, which would be someone who would be appointed by the government to resolve the dispute. And both sides would submit their proposals about what they want the collective agreement to look like, and then an arbitrator would craft a solution, and that solution would be binding. So if back to work legislation was passed by the federal government, this arbitrator would be responsible for hearing the parties and crafting a collective agreement that both would have to live with. So it would be imposed upon them. And so, there's a couple of things to say about that. One is that in general, in our labor relations system, we want parties to come to agreements voluntarily. Because it creates better labor relations when the dispute is over. If either side feels that they are living with a collective agreement that they really don't like, it can cause ongoing bitterness and, retaliation in the future, a diminishing of good working relations, good labor relations. And so that is to be avoided as much as possible. Back to work legislation is also much more difficult to use because of decisions that were made by the Supreme Court of Canada in 2015, in particular in a case called Saskatchewan Federation of Labor versus Saskatchewan. And in that decision, the Supreme Court articulated a constitutionally protected right for workers to use the strike as basically the only form of power that workers have to have leverage in labor relations and to make collective bargaining meaningful. And so in that decision and others that came around the same time, the court said collective bargaining has to be minimally impaired by governments, right? So they have to let things play out. Other options have to be tried to come to voluntary settlements before back to work legislation is imposed. It doesn't mean that governments can never do that, but they have to make sure that everything else has been tried, and that for sure the practice in the past sometimes to have preemptive back to work legislation to prevent this from happening, so that basically the parties are insulated from ever feeling the pressure from the other side. That's to be avoided. Particularly because for workers, it's the only pressure that they have to place on employers. Given that, the Minister of Labor has other options, and they could appoint a conciliator or mediator, someone who would not have the necessary role to impose an agreement, but would have the role of trying to help the parties communicate with each other better, to identify areas where agreement could be reached, to suggest areas of agreement where perhaps the parties haven't really seen those areas, and to try to help them figure out what trade-offs might make sense so that an agreement could be reached. And I think that there are also ways that mediator, if the minister were to appoint such a person, could also, make the parties' positions public, right? And so the conversation we were having earlier about the fact that we don't actually know what's at play at this table, even though this is actually a very important dispute from a public interest perspective. It's going on behind closed doors. We don't really know what's going on, and a mediator could potentially make some of that more public so that we all know where the parties stand, and the parties may also feel a bit more pressure to resolve disputes, change their positions if they knew that the public was going to see their positions. And I think that's perhaps particularly in the case of employers. And I think that would be of use. I think it's also very interesting that, this is a situation where we're actually not talking about legislating workers back to work. I mean, in this situation, we're actually practically speaking, talking about legislating companies back to work to tell companies actually you need to reopen your business. That's not really what's contemplated by back to work legislation, right? Like back to work legislation is something that targets workers. And this is a situation in which, although workers were ready to strike, they had strike mandates, they had renewed their strike mandates because you have to do that every 60 days in the federal jurisdiction. Like if you have a strike vote and you don't use your strike mandate within 60 days, you have to vote again. So they've repeatedly tested their members' willingness to strike, but they did not actually call a strike. They were locked out. And it's like, so are we talking actually about legislating companies back to work? That would be an unusual thing, and raises some important and I think interesting questions about rail and rail infrastructure in this country, and whether or not in the end it actually makes sense for rail to be held in private hands in this way. If it's so essential to the Canadian economy, why is it being controlled by two for-profit companies who are primarily beholden to their shareholders and not to the Canadian public or other Canadian businesses for that matter?
Well, here in New Brunswick, we have seen political figures, including Premier Higgs, calling for binding arbitration, while newly appointed Senator Jim Quinn called for even back to work legislation. We reached out to both and asked for a comment on the question of fatigue and have received no response. Previously, more than 100 industry associations or chambers of commerce called on Ottawa to immediately intervene without specifying exactly how. So I guess I'm just wondering, your comment on this pretty it seems like growing and pretty substantial pressure from businesses to get freight moving.
Yeah, I mean, but then again, I guess the question is, well, how do we understand this particular industry and its role in the Canadian economy? I mean, as you point out, right, New Brunswick Senator Quinn asked in his comments, like, why rail workers haven't been classified as essential. But I actually think that's the wrong question. The question is, why hasn't rail as an industry been classified as essential and therefore contemplated as a kind of public infrastructure that is so important that it shouldn't actually be subject to the private profit motives of a particular slice of Canadian business, or frankly, North American business, because of course with the merger of CP with Kansas City, we've got a company that is North American wide now. So like usually when people like Premier Higgs or Senator Quinn call for something to be made essential, they are really talking about essential in a very specific sense, right? They're not talking about essential as important. They're talking about essential as a way to justify the restriction of workers' rights and ability to bargain and have leverage in the bargaining process. They wouldn't be calling for that if, and they wouldn't have been calling for it, I don't think, had the union not been ready to strike. I think they're in a bit of a difficult and strange position now that it's clear that the companies are the ones that pulled the plug on negotiations, whereas the union says it was ready to continue bargaining, and in fact had only declared that they would strike at one of the two rail companies, so as not to cripple the whole Canadian economy, right? They were only going to strike at CPKC, not at CN. So, in our discourse about essential work and essential workers, this idea has usually been used to justify restricting workers' rights rather than think about the place that a particular sector has in the economy. Another way of thinking about it is to say, well, maybe rail infrastructure actually should be nationalized, and that it is not appropriate for something that is like the backbone of the economy to be held in private hands, that it should not be subject to the profit motive. It should be run as a public service. It should be invested in as a public service, as a crown corporation or otherwise. And that it's not that the question of the workers' essentiality is the wrong one. It's the question of the industry's role in making the economy work. And I think it's interesting that, you know, most people who are calling for workers to be made essential aren't thinking about that bigger structural picture.
It's interesting to note CN's official communications. They've basically stated that their conductors and engineers get plenty in wages and rest time, notably under the duty and rest period rules that were recently introduced by the feds. It's interesting to note that even those new rules allow for a 12-hour shift, which seems to me like a rather long time to be spent working on a train. As someone who's never worked on a train before, does seem like a rather long shift. But looking more closely at the CN media releases, they stressed that in 2023, the average conductor earned about $121,000. The average locomotive engineer earned approximately $150,000, not including pension and medical benefits. And CN says they work about 160 days per year. I asked for details about how they came up with this figure. The spokesperson said that includes 4 weeks of vacation, that is 20 days, 10 paid leave days, 10 sick days, and another roughly 10 other absences, unpaid. So it seems like the company's strategy here is to suggest that its employees are doing fine and really have nothing to complain about whatsoever. So yeah, just what's your take on this?
Well, I mean, I think that your point about the, how is that time actually spent and doing what is the real one. I mean, of course, the company is going to claim, yeah, these are well-paid workers, but these are stressful jobs. They are intense jobs. They are highly skilled jobs. They are jobs that involve a lot of risk to workers and to the public if they're not done right. And so, of course, they should be well compensated. And that it is clear, as we've spoke of before, that even with such rules, worker fatigue is still an issue. So there is something about those jobs that actually is quite exhausting, and affect employee performance. And I think it's relevant to then put what the average worker in this company does, and how they're compensated vis-a-vis, the executive group. For instance, CN Rail's CEO compensation this year was 14 million. Their salary alone, right, not including stock options and other kinds of bonuses, was 1.282 million. So if they are working the annual hours of their employees, 160 hours, if we take that as true, that's $8,000 an hour. And so I think this is a side issue. Like, I think if you want to talk about, who does the work that makes the company function, it's clear that they cannot run the company without their employees. And the relative compensation of employees, I think, undermines the argument that these workers are well paid. Well, well paid in comparison to what? And whose labor is producing salaries and compensation of 14 million? I mean, the situation is even more unequal at CPKC. The executive group as a whole has doubled their compensation since 2023. Keith Creel, the CEO, has seen their compensation go up 38%. So, they're taking home 20 million. So if we want to talk about like who's doing adequately well, we could equally say that the top end of the company, including shareholders, are doing fine, and they could stand to redistribute some of that wealth to the workers who are generating it.
Now, let's talk briefly about the status of the Teamsters in the labor movement. They're currently not members of the Canadian Labour Congress, which is often called Canada's House of Labour. And since they're not in the CLC, they can't be part of the NB Federation of Labour. I understand that the Teamsters were previously sanctioned for violating the CLC Constitution over allegations of raiding of the United Steelworkers. I think this involved truckers. What do you think these kinds of divisions in the House of Labour mean for the Canadian labor movement, and what, if anything, will it mean for this particular struggle?
I mean, I think that in general, it's better for all unions to be members of the Canadian Labour Congress. I think that it makes the Labour Congress more effective in its role to represent the voice of workers across the country. It means that they have more resources, they have more moral authority, all of that. And of course, it's better for them to be together. But from a perspective of this strike, I don't think it matters one bit. That I think when workers are when workers are locked out, especially, but also when they're on strike, the labor movement rallies around them, whether they're members of the Congress or the Provincial Federation of Labor or otherwise. We've already seen Bea Bresk, the president of the Canadian Labour Congress, issue messages of support to Teamsters Rail Conference today as they were locked out. That was true in 2021 when they were confronting, a potential strike at that moment. I think when it comes to the actual concrete organization of solidarity, unions and labor federations know that it doesn't matter if you're in the House of Labor or not. If you're in a conflict with your employer and you're also facing potentially the intervention of the government, what happens in your dispute matters to everyone else. And so everyone has an interest in workers winning those disputes. So I will be unsurprised to see members of other unions on Teamster picket lines, providing material forms of support if and as this dispute continues on. We've seen that with other unions that are not in the Canadian Labour Congress. So for instance, last year, Unifor is one of the, it's the largest private sector union in Canada, hasn't been in the Labour Congress for a while, also because of disputes over rating or questions of jurisdiction, which workers should go where, disputes over that were primarily centered in Toronto in that instance. Unifor left the Labour Congress, but when Metro grocery store workers were on strike last year in Toronto and the region, people from across the labor movement supported those workers, supported Unifor, put their money where their mouth is, put their bodies at the picket line, organized support. So when it comes to those kinds of conflicts, the labor movement comes together, and the question of organizational politics usually fades into the background. I might also even say that this is a moment when it's even more important for organizations like the Labour Congress or the provincial federations to show support for organizations that are outside of the House of Labour, because it could provide them with an incentive to come back in. So from my perspective, I don't think it's going to have any concrete negative impact on this dispute and the extent to which Teamsters enjoy support from other workers and other unions, because I think that people will understand what side they're on.
Thank you so much. I've been speaking with Professor Stephanie Ross from the School of Labor Studies at McMaster University in Hamilton, Ontario. Thanks for joining the NB Media Co-op today, Stephanie.
It's my pleasure.